I'm Georgina Jalbo from Lexis PSL, Private Client, and I have with me today Matthew Duncan, partner and head of the Private Client Department at Kingsley Napley. Matthew's going to talk to us today about contested wills and in particular the rectification of wills further to the Marley and Rawlings case. So Matthew, thanks for coming.
You're welcome.
In light of the decision in Marley and Rawlings, how far is the court prepared to go as to what may be included within the definition of a clerical error for applications under Section 20 of the Administration of Justice Act, when a will draftsman has clearly failed to properly give effect to a testator's wishes?
That's an interesting question. I think perhaps before I answer that, I'll just quickly explain. I expect most people are familiar with the Marley and Rawlings case,
Yes.
but just to quickly recap, essentially what happened was the solicitors had drafted two mirror wills for Mr. and Mrs. Rawlings, and then at the execution stage, unfortunately, Mr. Rawlings signed Mrs. Rawlings' will and Mrs. Rawlings signed Mr. Rawlings' will. And this wasn't noticed when Mrs. Rawlings died, but it was picked up when Mr. Rawlings died, and the issue then was, could this will be probated? Because essentially he'd signed the incorrect will. And the case was interesting because until this point, clerical error was very narrowly defined, i.e. a typing error that somebody perhaps made in a will. And so the judgment was interesting because it appeared to say that it could go beyond that and actually gave a lot wider meaning or definition. And I think from a practitioner's point of view, we all felt it was the right decision morally.
Yes.
And perhaps the courts had bent a little bit in a way perhaps Lord Denning used to in the past to try and find the right result to achieve what was wanted. Interestingly now for practitioners is how is this going to develop? And we've had a couple of cases post Marley and Rawlings. One of them is Brooke and Purton. And again, this was a solicitor who had inserted a particular clause into a nil rate band discretionary trust clause, which had the effect that it didn't carry out the testator's intentions or instructions. And the courts in that case felt they were able to rectify it and just deleted the offending subclause in the will.
Yep.
So that essentially got the will out, the solicitor out of jail, really, because the solicitor had made an error.
Yes.
But they're saying it was perhaps an innocent error, didn't understand the effect of it, and so rectification was allowed. Another case, which is Kellen Jones, went slightly differently. In this case, the argument here was that some charities had been inserted into a will which the testator hadn't wanted. And the court felt in this case that the solicitor drafting the will had deliberately put the clause wording in. And so they felt in that circumstance they were unprepared or unwilling to allow rectification, which seems a bit unfair. And it's almost as if the court are trying to interpret what was going through the mind of the will drafter.
Yeah.
And that really can't be right. It's going to be increasingly difficult for people or the courts to interpret how is a will drafter preparing the will, what is going through his or her mind. So on the one hand, it seemed if it's an innocent mistake, they're prepared to rectify, but if it's more of a deliberate act, then they're not prepared to rectify. And so for practitioners, that's quite difficult to see how this is going to develop.
Yes.
I suspect because Marley and Rawlings was such a unique case, it's almost laughable how it happened, but we can all as practitioners see how it happens, or how it did happen. And I would hope that going forward there won't be any other cases similar to it. And so while there is a concern that clerical error has been widely defined, I suspect the courts over a period of time will narrow it back down again, and there'll just be particular circumstances in which they'll allow rectification.
Yes.
And perhaps we're worrying a bit too much that actually where this law is going to go.
Yes. Yeah. Well, on the subject of solicitor error or errors made by draftsmen, with more testators preparing DIY wills or using cheap online wills rather than seeking professional advice, and with the number of contested probate claims doubling from 73 in 2006 to 135 in 2011, do you think we're going to see a continuing increase in the number of challenges to the validity of wills?
I think undoubtedly we are. Certainly for my practice it's increasing, and a lot of that is due to homemade or DIY wills. I think there's a general public misconception that wills are simple and it doesn't involve spending huge fees with lawyers to have them drafted. And so there is a temptation by testators to get a DIY kit, to do it themselves, or perhaps use a will drafting firm that will charge a very low fee and get their will prepared. I think the difficulty with the way that society is changing is that our lives have become more complex. We have a lot of families that obviously divorce or remarry. They may have children from different relationships, and so you often have lots of different complexities to somebody's estate that perhaps in the past wouldn't have been so normal. And as a result, a basic will perhaps doesn't cover what's needed, and this is where mistakes are coming in. It could be just to the drafting itself, there's an error been made, or the testator hasn't thought about his wider family, stepchildren, etc. And this is why you're seeing there are more and more claims.
Yes.
I think it's also fair to say that as people get wealthier, the nil rate band has been pegged at the level it is. There's more inheritance tax being paid. So you can see anecdotally people are more wealthy, and as a result, wealth tends to bring dispute. So
Yes.
you're finding more and more people are challenging wills because they feel they've been hard done by, or they feel they're entitled to an inheritance. And so you're seeing a lot more litigation. It's also fair to say that people are a lot more aware of their rights and a lot more prepared to pursue those rights. So you're not seeing people just saying, oh, okay, I didn't benefit from my father's will, that's it. They're actually, no, they'll challenge it.
Yeah.
Whereas in the past, perhaps they wouldn't have done so.
Okay, well, thank you very much for those insights, Matthew.
You're welcome.
Good times for contentious probate lawyers.
Definitely, yes.
Thank you very much.
You're welcome.